This video explains the 5 simple steps to manage your risks as a medical practice owner. It's a question that I get asked a lot, and I think that some medical practice owners are nervous about a whole bunch of risks that they don't know that they don't know. So hopefully this video can put some of the... You'd be disappointed if I didn't start my video with a disclaimer. This video is for general guidance only, and legal advice needs to be sought in relation to specific issues. So who is this video for? This video is for any doctor who wants to understand and manage the risks and obligations associated with running a medical practice. This video, you're going to learn about the risks and obligations associated with owning a medical practice. You'll also learn the steps that you can take to understand and to manage those risks and have a framework and strategies that you don't have right now. Do you ever lose sleep worrying about the unknown risks in your practice? Do you ever think about what might happen if a claim came through the door that you had never anticipated in your wildest dreams? Do you feel so overwhelmed worrying about your risks that you would rather put your head in the sand and never think about it again? Well, that's not the real problem. Although it is a problem, the real problem is that you haven't implemented the 5-step risk management method. Once you apply it, you're going to be empowered to grow your practice because you know you will understand your risks and, importantly, how to manage and mitigate them. So, for those of you who don't know me, my name is Sarah Bartholomews. I run a law firm called Unveil. I'm a lawyer and I have been for 20 years now. I come from a family of medical and health professionals, including a general and orthopedic surgeon, a dentist, a physio, a nurse, and my cousin Gabby has just started her specialist training to become a pediatric immunology expert or something that sounds cool like that. I've written and published 3 books on governance. 2 of them I'm going to talk about in this video. And the other one is a book called Growing a Medical Practice from Frustration to a High-Performance Business, which has a whole chapter on risk. I also am a podcaster, and I've launched a podcast called Accountants on Purpose late last year and a new podcast called Hacking Health. I've worked with over 1,000 doctors in the past, and ULegal only works with clients that have a purpose that's higher than profit. And doctors fall perfectly within that because you help people directly. And by helping you, we feel like we're part of the ripple effect of helping others. Not a lot of lawyers can say that about their practices, so it's something that we feel grateful to be able to do every day. So onto the important topic, discovering the 5-step risk mitigation method. But first, what is risk? Well, it's quite simply exposure to danger or harm. And this doesn't just mean in terms of profit or property, but it can be damage to your reputation or damage to the goodwill of your business. So, importantly, risk management is not just about avoiding risk, but also learning how to identify risk, profile its consequences, and make calculated choices about what to do with that. Your risk, as well as your risk appetite, is diverse as the people who watch this video. It's really important to understand your risks as a director. So first up, I'm going to go through your risks as a company director. A company is a separate legal entity. It has rights and responsibilities on its own. And as you probably already know, it has to do its own tax return. So what is a company director? A company director guides and monitors the management of the company for most smaller businesses and smaller practices. Most company directors are very heavily involved in the management of the company. Even if you're not heavily involved in a corporatized practice, you can't get out of your director's roles and responsibilities. The Corporations Act defines the meaning of a director as a person who's validly appointed, or a de facto director, or a shadow director, or an alternate director. So what are directors' duties? Directors' duties fall into 2 main areas. They are fiduciary duties and statutory duties. A fiduciary duty is an obligation first and foremost to act in the interests of another and not in their own interests as advisors. So who are directors' duties owed to? We talked about a company being a separate legal entity, and as a director you owe duties to the entity as a whole, not to your partners, to the community, to other people, but to the entity. So remember, first and foremost, that's who your obligation is to. Directors have a duty to act in good faith. The duty to act in good faith is a statutory duty as well as a fiduciary duty. So your decisions as a director need to be made in the best interests of the company and for a proper purpose. The tricky thing about this duty is the concept of good faith can change depending on the circumstances. To determine whether you're acting in good faith, you need to consider your intention. Is it your intention to act in the best interests of the company, or would a reasonable person in your circumstances view your actions as being done in good faith? You need to exercise your discretion in a way that you honestly consider to be in the best interest of your company. The next one is the duty of care and diligence. You must carry out your duties with a degree of care and diligence and not be negligent in managing the company. The standard of care will vary depending on a range of factors, including what type of director you are, the size of your organisation, and the specific and personal experience, your skills and skills of your fellow directors as well. I'm sure you're all aware of what a conflict of interest is, but did you know it applies to you as a director as well, particularly if you're a director who works within the medical practice that you own? It overlaps with the other duties that we've covered and can be difficult to manage. You've already got a conflict as somebody who wants to earn money from the practice but is also a practice partner. So what can you do to avoid a conflict of interest if you're having board meetings? Well, it's really one of the things that's all about effective communication, and rather the way that you manage and disclose the conflict will determine whether you've breached any duty. So there's a list here on how to identify if you have a conflict. This slide has a number of ways to deal with it. If you're moving out of the room during areas in which you think you might have a conflict, that can be an excellent move. Communication and disclosure are the primary obligations and ways to avoid breaching this duty. As a director and owner, you'll be given an opportunity to read highly sensitive material relating to the operations of the business. Improper use of information means you're not allowed to use this information to gain a personal advantage, gain an advantage for someone else, or cause detriment to your company. A good example of improper use of information is the case of Steve Vizard when he was a director of Telstra. You might recall he used information improperly in relation to a company that Telstra was looking at acquiring, and he bought shares in that company before it was acquired. When the business was bought, the shares went up, and he was consequently banned from being a director for 10 years and was publicly shamed, and it really put the end to his director career. So evidently there can be serious consequences from breaching director's duties. The duty to maintain confidentiality is also a fiduciary duty that's embedded in the duty to act in good faith. Fiduciary is a Latin term and it means trust. And as doctors, you already know deeply what fiduciary means. As the director of a company, you have a fiduciary duty to act in good faith and to maintain the confidentiality of your practice's information. This extends to your duty to maintain that your employees are aware of the nature of any confidential information and it must not be disclosed to people, anyone in general, in the general public, or even in some cases, other members of staff. Directors, regardless of under what capacity you've been appointed, have an obligation to monitor the financial position of the company, maintain proper financial records, report accurately to shareholders and also to regulatory bodies to prevent the organisation from trading insolvent. In some cases, directors should be taking extra courses to understand or find a way to read financial statements. It's not something that's taught in law school and it's not something that's taught in medical school. So it can be time and money well spent learning about that. What if I breach my duty? There are varying penalties that apply and can range from fines to imprisonment. They can be as broad as the duties themselves. A serious breach, which might involve gross negligence or recklessness, as well as offences with elements of fraud or dishonesty, can be criminal and lead to imprisonment. Now I want to talk about strategies in risk management. First, there's 4 steps: avoid, mitigate, transfer, and accept. Here's some examples of how they apply as a director. Participating is mitigating your risk because you're participating as a company director. You know what's going on and you're helping make decisions. Making decisions in the best interest of the company is a mitigation strategy. Being diligent in carrying out your duties and responsibilities, being transparent, ensuring that the company has appropriate directors and officers insurance. If there's more than one director, it's highly recommended that you're talking to your insurance broker about that. It's often worth the investment, but it won't cover you for cases of negligence or recklessness. Considering also having a deed of indemnity and access. A deed, if you've got multiple directors, will provide a promise that the company will maintain the directors and officers insurance and provides an indemnity so that if there's some breach by you, you're transferring that risk to the company, which you can do in most cases, but not where you're being reckless or negligent or acting in a criminal way. It won't protect you against those things. And then that deed will also provide you with access. So if you're no longer a shareholder or a director of the entity, it gives you about 7 years to have access to documents that you might need if you get called before a regulator or tribunal or some sort of organisation that you don't expect to in litigation, and you need access to documents. And then this deed can be critical in that respect, especially if the practice has changed ownership and you don't have personal relationships with anyone anymore. I wrote a book about this if you're interested. It's called How to Avoid a Fall from Grace, and it was launched in 2015 in Times Square. It's been updated to include new provisions on safe harbour, which is an insolvent trading defence. So if you think it might be some financial issues going on with the practice, then you can call in a turnaround specialist to help with that. The books that I previously mentioned have all been updated, and I'll pop the links to buy these in the notes underneath the video that I'm sending. So I can sign books for you if you do order them. If you're interested in buying them, they're available on our website. Step 2 is to understand that your staff are a risk in your business. I never recommend that people try and run a practice on their own without staff, but staff, as well as being your greatest asset, are also a liability. You've got obligations under workplace health and safety, and every person who conducts a business does. You've got a duty to ensure, as far as reasonable practical, that the health and safety of your workers and other people in your workplace, so patients and people who come in to work on the building, are protected. Individual workers should know that they also have a duty of care at work to exercise their own duty of care for their own health and well-being and that of others. To comply with workplace health and safety laws, medical practices do need to understand and undertake risk assessments in terms of managing those risks. And medical practices, you just need to do what's reasonably practicable to eliminate the risks or minimise them as much as possible. This is part of it, but also as an owner of a practice, you're vicariously liable for the acts and omissions of your staff. Staff can damage your practice by starting competing practice close by and taking your practice list. They can take staff or they can take patients. Staff can damage your reputation in the community by speaking unkindly about you or your practice. And what can you do to help manage these risks? Well, you can have written agreements with all staff, policies and procedures, and can also help mitigate risks associated with employees. And as part of accreditation, you likely have a whole suite of those under your belt already. What you might not have is a delegation of authority policy to ensure that you've got clarity in relation to areas of responsibility for what's expected of certain staff members. Can your practice manager go down to the shop and buy milk without asking you? Can they get stamps? Can they buy a piece of equipment without your permission? At what point does their delegation get set? And have you got that documented? As I mentioned earlier, the 4 strategies in risk management are avoid, mitigate, transfer, and accept. How can you protect yourself as an employer? Proper agreements with staff, obviously avoiding risk and transferring risk, and in certain circumstances, back to the employee policies and procedures, also avoid and transfer disclaimers and consent forms. Insurance is also a risk that you're transferring to somebody else. Understanding potential risks is step 3. Potential risks can include this list, which I came up with from my book, Growing a Medical Practice from Frustration to a High Performance Business, and they're all relevant today. Some of them are scarily relevant, as pandemic is number 4, but running a business creates different types of risks and reward. Unlike patient and doctor risks that you deeply understand, there are many types of business risks. Risks can be internal or external to a practice. They can also directly or indirectly affect the practice's ability to operate. Risks can be hazard-based, like chemical spills or natural disasters, where there's uncertainty-based association with opportunities, which could be taking them up or ignoring them. These types of risks that affect any business could be specific to your practice and your goals, just like what you do with patients. To effectively manage patient and practice risk, you should think about and prepare for internal and standard scenarios that may directly affect your business. So I've got that in the list: natural disasters, legal issues such as insurance dispute resolution, contract breaches, non-compliance with regulations, global events like pandemics and interruptions to air traffic technology like computer network failures, problems associated with outdated equipment or cybersecurity. There could also be regulatory or government policy changes, carbon emission restrictions, tax changes, environmental issues like climate change, chemical spills, location of your work and property and equipment damage, from burst water pipes to robbery or vandalism, security concerns like theft, fraud, loss of intellectual property. We can also include in that list cash flow shortages, rapid growth, rising costs and staffing can affect that, filling vacancies, suppliers who go out of business, issues within the business or industry that result in failure or interruptions of the supply chain. There are potential risks. So sorry to scare you, but just like everything else, the way that we can think about them is by choosing to avoid them, mitigate them, transfer them, or accept them. And some examples for potential risks are making sure you've got all your insurances in order. Agreements are all in writing, which can help transfer and avoid risk. And then also having backup suppliers to help you mitigate your risks. Ensuring you're reviewing your risks regularly to see whether you can avoid, mitigate, transfer, or accept them. Number 4 is understanding indirect risks. And thinking about them is the first step. So you do have indirect risks in your business, even maybe if you haven't thought about them. I mentioned before the supplier-related risks, patients being personally affected, changes in priorities, or the general location of your practice might be affected, which would have nothing to do with you necessarily, but still have an impact on your practice. Once you've come up with your list that affects your strategies, avoid, mitigate, transfer, and accept, how you might mitigate or manage indirect risks remains as agile as possible. Avoiding and mitigating, having good communication and relationships will help you to avoid and mitigate as well. Thinking about those things in a meeting with your fellow partners and a practice manager, of course, can really help. Why I say not to do it alone is having the different people think about things is extremely valuable. People think about things differently and can help you in your practice because it can help create a different perspective about how we do things and how to get the best result. The book that I wrote about risk is called Kingpin: Legal Lessons from the Underworld. It's a book about drug dealers and how they deal with risk. Drug dealers participate in a market that's completely different from ours, but that has huge risks for them personally, for their business and for their families. I found it so interesting thinking about our risk as ordinary business owners in relation to these drug dealers and how they manage risks in their business. Without knowing it really, what they do is they have policies and procedures. The lessons from them are as relevant today as they were then, and they're relevant to regular business owners as well. So this book is also available on New Legal's website. Step 5 is to leverage an expert. If you don't feel like you've got the in-house experience to do this, using an expert can bring new ideas, best practice, and accountability. And it's a little bit like having insurance. You pay for an expert to do something that you don't know how to do, and it would take you an incredible amount of time to become an expert in. One of the things about risks is that it's really hard to know what is worth avoiding and what risks are saving you money. So putting something in place like an agreement with an indemnity, which requires your doctors to pay back any money that you pay on their behalf after a shared debt recovery obligation comes back to you because they haven't paid it, you just don't see that risk if it's managed properly. So that's what we aim to do here at ULegal. And there are new ideas in your head that wouldn't be here now if you hadn't taken the time to tune in today. I promised that you would understand the risks associated with owning a medical practice and have a step-by-step strategy to implement them in your practice and manage those risks. Those steps are understanding your director-related risks, understanding your staff risks, understanding potential risks, and understanding indirect risks, and then, of course, leveraging an expert. Once you implement this, you will have enough knowledge to legally protect you and your fellow practice owners and whatever the future may hold. But protecting your practice isn't free. Now you have a choice. If you're willing to invest in protecting in yourself and your practice, my team and I can help you by jumping on a 15-minute call with you and your practice manager to discuss running a risk project with you so that you can sleep at night. New Legal can work with you to manage that risk. We'll figure out if we're a good fit to work together, and we'll know at the end of that 15-minute call. So look forward to meeting you. The link to get in touch to organise that call is in the comments. Thanks for tuning in.